Good afternoon, folks, and welcome to the third in a four-part webinar series that Rosconn Strategic Land have undertaken in conjunction with the team at Farmers Weekly. For those of you that are watching one of our webinars for the first time, my name is Dan O'Donnell, founder and managing director of Rosconn Strategic Land. We're a land promotion company that creates sustainable developments and communities across England, maximising landowners' asset value by promoting it through the planning system and selling the land to the open market in a trusted, transparent and innovative way. You can find out lots more about the company via our website, rosconnstrategicland.com. Please feel free to navigate some of our interesting case studies at your leisure. This afternoon, I'm delighted to be joined by Nick Carr, our Operations Director, and Dan Hatcher, our Planning Director. We're going to be taking you through how to prepare your land for sale. And by the end of the webinar, we hope you will be better informed after listening to us discuss matters such as land title, vacant possession, VAT registration, retain land, and how to make the buyer's job more easy to ensure your land parcel is top of their list. As always, we will have two polls, the first of which will be out shortly. We will provide the results of the first poll after the presentation. The second poll will be released before the exciting Q&A part of the show. You've been asking some really interesting questions, and we are very excited to be answering some of these for you. Any questions that we don't get to answer this afternoon, don't worry, we will answer those separately. Our thanks goes out to all of you that have registered for this afternoon's webinar, and so far the count is 158. The first poll question is about to be released. How many of you are in the process of selling land? So without further ado, I'll hand over to Nick, who's going to start the presentation. Nick, over to you.
Thank you, Dan. Hopefully this afternoon's episode will give people some helpful tips if they are currently selling a land parcel for development or plan to in the near future. As a starting point, I would thoroughly recommend coming up with a pre-sale checklist covering the items such as taxation, boundary features and searches. I'll cover all of these in more detail over the coming slides. Also, we will be making a copy of this presentation available, so there's no need to start frantically writing down the list in front of you. At the outset, it is really worth investing some time to carefully think through the sale process, both in terms of the paperwork, like the status of the title, and the practicalities, like what needs to be moved in order to provide vacant possession. Doing so at the outset should make the process of sale all the smoother and minimise the risk of delays down the line. When undertaking your pre-sale checklist, there seems no better place to start than undertaking an audit or health check of the title, as ultimately this is what is being conveyed to the purchaser. Your solicitor should be able to assist on this, particularly with some of the more complex items. First and foremost, is the property actually registered with Land Registry? When a property is first registered, the Land Registry extract relevant details from the title deeds to create a registered title. When a property is sold, the Land Registry will consider the application submitted on behalf of the purchaser to make sure that the correct documentation and evidence has been provided and update the registry accordingly. If the land has not yet been registered, the most straightforward way to deal with this is to produce the physical title deeds to demonstrate ownership. If the deeds are lost, though, it will be necessary to provide evidence to the Land Registry as to why the deeds are lost and why you are in fact the true owner of the property. This, as you might imagine, can become complicated and lead to delays, so ensuring that you have the deeds available and if not, applying for registration now is strongly advised. If a sale is some way off still, it's recommended to proceed to register the title now, as you do not need to wait until a sale to do so. Having the title registered should make for a smoother transaction when the time comes. Assuming that the title is registered, is it up to date? For instance, is the name on the title the name of the person selling? It may be that the property has passed to another family member following the passing of that individual. If that is the case, it will be necessary to establish a link to the property and the person selling. This is generally via the grant of probate. If probate has been granted, we would recommend that the title is also updated with Land Registry so that the title reflects the situation as it is now. Also, what entries are on the title? These may contain mortgages, restrictions, or leases. If an entire property is mortgaged and only part is being sold, then you will need the approval of the mortgagee for the sale of part. What about restrictions on the title? This is fairly common, and it's where consent is required from a third party in order to sell the property. Generally, you will find these as a device to ensure that positive covenants, i.e., those that require someone to do something, run with the land. Otherwise, they fall away once the land changes hands, unlike restrictive covenants. Depending on how the restriction was put in place, it may be possible to self-certify the compliance with the restriction by either your solicitor or the buyers. But often these can be more onerous, and you may actually need the consent of the third party to sell. Getting an understanding as to whether there are restrictions on the title and the nature of these restrictions at the outset is key to avoid a potentially nasty delay as a sale completion approaches. Less common with agricultural land, but if the land has historically been let and the expired leases are still on the title, this will need to be removed prior to the sale taking place, as this would then remove any question mark about the former tenant having a continued interest in the property. The last item on the title health checklist is restrictive covenants. These run with the land and can limit or even prohibit development of the site, so knowing about these at the outset is key. If these are present, negatively impact on your proposal and you can identify and find the beneficiary, it may be possible to negotiate a release from the covenant, but this will be a commercial negotiation, will take time, and is not a guaranteed solution. An insurance policy may be attainable that doesn't remove the issue, but will financially protect the buyer against the risk of the covenant being enforced. An insurance is typically the preferred route where a policy is available and is well suited to situations where a covenant has been on a title for a very long time and the beneficiaries cannot be identified. If a restrictive covenant only affects a small part of the property and the issue has been identified early enough, it may also be possible to amend the proposals for the land so that the covenant is not breached. There are also options to pursue the removal of a covenant through the courts, but in the interests of time, I don't propose to go through these today. Next up is vacant possession, and this can be split into two categories, the first being the technical and the second being the legal. Is the property let? If not, great, but if it is, it's important to understand the nature of the lease. A farm business tenancy is typically any agreement agreed after the 1st of September 1995 and can be ended early by issuing a notice to quit, but with a minimum notice period technically being 12 months. That said, agreements will often have shorter periods referred to where the land is being sold for development purposes, most typically 3 months, and by negotiation it may be possible to shorten the period still further. If the tenancy predates September 95, then these tenancies are known as 1986 Act tenancies or Agricultural Holdings Act tenancies. And the tenant has lifetime security of tenure. And those that predate the 12th of July 84, they even benefit from a statutory succession right. On the end of that tenancy, the tenant is entitled to compensation for major long-term improvements to the land, short-term improvements, and what is known as tenant right, such as the value of growing crops and compensation for disturbance where the landlord terminates the tenancy with a notice to quit. An assured short-hold tenancy, or AST, would cover a residential property, and after an initial 6-month period is terminable, typically on 2 months' notice. However, the notice periods have fluctuated during COVID, and currently the minimum notice period is actually 4 months. That said, it should be pointed out that if a tenant holds over at the end of the notice period, they cannot be automatically evicted, and the ability to do so must be secured through the courts. Given the potentially lengthy vacant possession period in tenancy agreements, it is highly advisable that these are thought through at an early stage. So what about the practical? Firstly, what is being sold? Is it just a field, or does the land contain a house or barns? If it's purely a field, then this is more straightforward, but still requires some thought. For instance, where will the livestock be kept post-completion? Post-completion, or if arable, ideally one would time a sale to minimise crop loss, be it after harvest, or to not plant out a crop where a sale is likely to occur during that growing season. If there are buildings, then think through the logistics of relocating what's inside them, or even the structures themselves. Ideally, you want to avoid a last minute rush to clear the land being sold, as if being sold for development, there will be an expectation that the site has truly been vacated with belongings cleared. Moving on to taxation, which is a major consideration when selling land to ensure that the eventual net receipt is maximised. Firstly, VAT, and whether you need to register for VAT or not when selling land. The default position is that VAT is not applicable to the purchase price of land. However, it is possible to opt to tax with HMRC and charge VAT. But why would you do that? Well, if the land is being sold without the involvement of a land promoter, there is probably no need to do so. If, however, a promoter has worked on the project, that work is a service, and as such, VAT is payable on their fee. If one registers for VAT and opts to tax, then the VAT can be reclaimed by submitting a VAT return to HMRC. Depending on the value of the land being sold, the VAT payable on a promotion fee is likely to be significant, so it is well worth registering for VAT to ensure that this money is recovered. The process is straightforward, and any experienced tax advisor should be able to assist. We would, though, recommend dealing with an accountant who is experienced in the sale of agricultural land for development purposes to ensure that this is done correctly at day one. It is also worth thinking about when to register and opt to tax. Generally, provided you are confident that the land is going to be sold, the sooner the better. The current time HMRC are quoting on their website for VAT registration is 30 working days, so 6 weeks. It is also highly advisable to make contact with your accountant or find a specialist accountant with experience of selling land for development. If you don't have one, I would strongly advise this is done well in advance so that the accountant can fully consider your current circumstances and work through the most appropriate tax planning steps. Often these take time to be put in place, so the sooner a discussion is had, the better, to ensure that any tax liability is minimised. Another really important thing to give careful consideration to right at the outset is what is left of the farm, assuming you are only selling part of a wider landholding. This can be as simple as what is the boundary structure going to be to the retained land and who is going to construct and maintain it moving forward. The earlier the better, as certain structures will require planning permission, and if the idea is some form of landscaping feature, you want to ensure that this is picked up in the master plan for the wider development. Also, how does the land you are selling interact with the retained land? Does your retained land drain through the land being sold, or are there services running through the land that you will continue to need to utilise? You need to make sure these are picked up so that the transfer of the land continues to allow for rights to use these moving forward. Similarly, if the land you are selling may need rights over your retained land, particularly if the site being sold is draining to a ditch or watercourse in your retained land. Also, does the land you are keeping have any future development potential? Perhaps not in the short to medium term, but what about in 30 or even 40 years' time? If the answer is yes, it is important to retain rights over the land being sold to allow for future access and services through that site. Otherwise, you could be effectively ransoming yourself in the future by disposing of part of your land holding now. Equally, the land you are selling may adjoin land that is not in your ownership, but that has future development potential. In that instance, it is advisable to retain what is known as a ransom or control strip along the boundary. This is simply a narrow strip of land that is retained by you so that any future road or footway to that land parcel will have to pass through your land, which can attract a financial payment. Thinking about this at the outset allows the developer, where possible, to master plan the scheme so that these rights can be practically delivered, and also potentially to ensure that your retained land has the best prospects of securing development in the future. The last thing to think about and that I'd like to touch upon is the importance of trying to make a buyer's job as easy as possible. Now, a lot of what I've talked about so far today will help massively with that, but also providing them with the property information they need up front will make a sale all the more streamlined. A buyer will raise a set of standard inquiries relating to your property known as CPSEs, or to give it its full name, Commercial Property Standard Inquiries. You can, with assistance from your solicitor, carry these out in advance of the sale being agreed so that this information is on hand at the outset. A purchaser will also understand their own undertake their own searches, such as local, highways, and environmental. If you're working to a short timetable, it is advisable to commission these yourself for the buyer to rely on so as to avoid delays with the exchange. Even where there may be less urgency, we are aware of certain searches in parts of the country that take several months to come back. In particular, local and highway searches are experiencing delays. I'd therefore recommend speaking to your solicitor to discuss whether certain searches should be put in place now. If the land is being sold for development, most of the surveys that need to be undertaken will have been carried out as part of the planning process. Typically, however, a detailed ground investigation is not required on a greenfield site, but will be needed by a purchaser so as to accurately cost the build project and to ensure the degree of any abnormal ground features or contamination. These can take several weeks or even months to undertake, particularly if there is gas monitoring needed, so providing this information to the buyer in advance of sale is recommended. Another survey that is often required where buildings are present that are going to be demolished is asbestos, and again, we'd advise commissioning this yourselves to save time. One final big point to note is that if you're selling a planning permission, any purchaser is going to need to be able to rely upon the surveys, reports, and plans that underpin that permission. It's important, therefore, that these are commissioned on the basis that they are assignable, and ideally you would also look to agree the wording for this assignment with the consultants at the outset. I hope that this has provided a useful summary of what to consider when selling land and has given you some things to think about. I know that we've had some great great questions from the audience in advance of today, and we'll do our best to work through those as well. But if people do have further questions, please do submit them and we'll try our best to answer.
Thank you, Nick, for a very comprehensive and informative presentation. I sincerely hope that the viewers are better informed about the checks and balances that are required ahead of taking development land to the market. I have to say, over the years that we've been working together, I've found our pre-sale checklist that you put together very useful for when we sit down with our landowners and their advisors ahead of marketing. It brings everything together in a stress-free and cohesive manner, which simplifies matters for our landowners, ourselves, and indeed their advisors, and hopefully for the buyer. The results of the first poll are in, and Nick is going to tell us the results.
I am, if I didn't have an IT failure.
Well, don't worry, because what we'll do therefore is we will read out those results. You'll read them when the IT failure is sorted. And the second poll will be released soon. And having heard how many technical reports are required in addition to the cost of the planning process, how many landowners would choose to promote the land personally and pay all the costs instead of engaging a promoter? So that's poll question 2. I think that's an interesting one. Be interesting to see.
I've now overcome my IT failings.
Great.
And I have the results. So yeah, 7% are currently selling, 35% not currently looking to sell, but 58% are going to be selling or looking to sell in the near future.
Great. Yeah. Well, interesting stats as always. Well, now it's time to move on to the exciting Q&A part of the show. That's not to say Nick's presentation wasn't exciting, because it was, but the Q&A session now gets under the bonnet of the subject, we hope, with some of these great questions. And we're delighted that questions are still streaming in from viewers. So on to question 1, which has come from Pete. Pete, you're asking, how is the marketplace for land in the post-Brexit, post-COVID era? Question mark. Do you see an upturn in land values when the economy recovers and reopens? Pete, I'm going to take this question if that's all right. And it's an interesting question due to the unprecedented times that we find ourselves in. I know unprecedented times has been overused so often in the past year or so, but they really are unprecedented. And during the first 3 months of lockdown 1 back in March 2020, it's fair to say that majority of the house builders came out of the land buying market so that they could observe what was happening, what was going to happen with the economy. We had a huge pandemic ripping. What was happening? So it was time to observe the market, frankly, and how it was going to react. What we all found, however, was once the housing market and economy stabilised due to the sterling efforts of the Chancellor and the Bank of England pumping money into the system and providing stamp duty relief, then house builders became more confident as houses were selling. And this in turn made the builders more confident to buy land. So we actually saw as Rosconn an uptick in demand for land, which pushed up land values. And this, let's not forget, was buoyed by a scarcity of available land that was benefiting from planning consent. Now, moving to Brexit, this is an interesting one because the main impact here that we're seeing from talking to house builders and development companies alike is the impact of supply of materials and labour, which is the major impact. We haven't thus far seen a drop in land values, but as I just mentioned, we think a huge part of that is the lack of available land with planning consents, making the demand greater, and therefore each time Rosconn Strategic Land bring a land parcel to the market in order to maximize its value, we're noticing that the tendering process is extremely competitive. But crystal ball gazing on the market and values is a dangerous thing to do. But in my opinion, Pete, for what it's worth, for as long as planning permission remains as often slow and cumbersome as it can be to obtain, I believe that values will hold strong and increase in the most sought after areas. Question 2, Simon, you're asking if there are parts of the land with woodland, say 20%, how much lower are they valued, and is it worth cleaning it up and thinning parts to improve price? Or is it good to have part woodland as animals love it? Well, if there's one member of our team that does love a good woodland, that'd be Nick. So, Nick, if you don't mind answering this one.
Yes, thank you. If it's 20% or less of part of a larger site, perhaps 7 or 8 acres or above, it needn't necessarily be an issue, as any site of that side is typically going to need to be providing 30 or 40% of the site as green infrastructure anyway. So therefore, that part of woodland could just form part of the public open space green infrastructure that is the site's going to need to provide anyway. And it can also help from a biodiversity point of view, as you've got a ready-made habitat on the site that you can look to enhance. And also, depending on the location within the site, it may also assist, for instance, if it's on the edge of the development, and it could then play a part in shielding the development from the wider impact of wider impact on the landscape. So it needn't necessarily be detrimental to the site's prospects. And I personally caution against unilaterally felling trees. I think anything above 5 cubic meters requires a license from the Forestry Commission, and felling would likely be accompanied by a wider replanting scheme. So in that license process, you'd then need to agree a scheme for fresh planting with the Forestry Commission, which is likely to be more extensive than the planting that you've already got on the site. So yeah, if it's the minority of the site, I think you should be able to work within it. I think the only time where it's really going to be problematic is where that woodland is the parcel of land that's directly abutting the settlement, and therefore the most logical part of the site to be developed. But that would be more problematic. But in the main, 20% or less shouldn't be unduly problematic.
Sure. No, I'd agree, Nick. No, very, very useful. Question 3 is coming from John. John, you're asking, I have an option agreement with a house builder. Does that mean I need to register for VAT? Sounds like I'm picking on him, but again, all matters VAT, value added tax, our little VAT in-house specialist, that'd be Nick.
Thank you. Yeah, a fairly short answer on that one. In essence, yeah, it shouldn't be necessary if dealing with a house builder, as they're the actual end purchaser, whereas it's in a promotion agreement where that promoter, such as Rosconn, is providing the service. That's where it attracts VAT, and in order to reclaim that VAT, you'd register. But if it's an option with a house builder, that shouldn't be required.
No, and as you said earlier, Nick, if you need to register for VAT, get on with it nice and early.
Absolutely.
Question 4 has come in from Beth. My tenant has the benefit of a long-term agreement dating from the 1970s. What rights do I have to obtain vacant possession? Well, Nick, I think this is relevant actually to one of the sections of your presentation. So perhaps if you'd like to take this one.
Definitely not picking on me.
No,
no,
never would.
Yeah, no, yeah. Fortunately, yeah, it's area covered off earlier. But even though the tenancy dates from the 70s, it will be covered, as I understand it, by the Agricultural Holdings Act from '86 that I mentioned. And there are several grounds for terminating a tenancy within that act. And the most straightforward in the case of where you're looking to develop the land, the most common trigger is that if the land is required for use other than agriculture, i.e. it's being developed for residential or commercial purposes, that would be a trigger whereby you could obtain vacant possession. I think, yeah, just one thing to point out with that, which I very, very briefly touched on, is one of the other triggers is actually the death of the tenant. However, as your agreement is from the 70s, so it actually predates the act, there are succession rights that I touched upon. So relatives of the person dying, so children and grandchildren of that person can apply to succeed. So even if the existing tenant were to decease, there is the potential that their successors in title may look to take on that tenancy, and that can happen not once but twice.
Sure. Okay. Alrighty. So we're on to question number 5, which is coming from Roger. And Nick, all I'm saying is I'm not picking on you, but Roger's specifically picking you out. Nick, you mentioned the possibility of removing a restrictive covenant through the courts. Please, could you expand on this? I have a restrictive covenant dating from the 1920s and wonder whether this would be possible. Over to you, Nick.
Thanks, Roger. Yes, it would potentially be possible. Generally, given that sort of age, your starting point would be insurance, but it is possible to submit an application to the upper tribunal or lands chamber to have that restriction removed. So I think, if you've got plenty of time, if this is just something, development on the land or looking to sell the land, something a long way off in the future, then that could be an option. There are several grounds again that you could argue, and the most common is that there's been a material change to the property or the neighbourhood that means the restriction can be considered obsolete. So if you've got a covenant dating back a century or more, and obviously the character of that area is wholly different now to how it was a century ago, then you can argue it's obsolete, it no longer applies, and it can be removed. And the advantage of that versus an insurance policy, if you've got the time, is provided that that's successful, there's absolutely no doubt it is unequivocally removed from the title. Whereas, as touched on in the presentation, insurance policy, it's great. However, technically the covenant is still there; it doesn't go away. So, if time is on your side, it might be something to consider.
Yeah, absolutely. And again, it comes back to it, forward planning and getting on with these things nice and early with your legal team and promoter. Question 6 has come in from Vivian. Vivian, you're asking, how relevant are the existing plans of A, the local planning authority, and B, the neighbourhood? Will they still guide decisions, or should we wait to see what the government's new policy will say? Let's give Nick a rest day and ask Dan Hatcher. Over to you, Dan.
Thanks, Dan. Yeah, it's a good question. I think it's something we constantly have to wrestle with on a regular basis due to the complexity of the planning system. I mean, yes, the planning system is a plan-led system. So I think in the first instance, yes, they're very relevant, both local plans and neighbourhood plans where they're in effect. But you do have to, is it every case on its merits or on a case-by-case basis? You have to look at how old that local plan is. If it's over 5 years old, then it can be considered out of date. You also have to look at the housing land supply in a particular authority. Have they got a sufficient supply? So that's sort of measured on a yearly basis, and basically each authority has to demonstrate they've got a 5-year land supply. So that's a 5-year supply of deliverable sites with planning permission. So if they haven't got that, then it does weaken the relevance of those existing plans. And as Dan mentioned earlier, the planning system is cumbersome, and because of that, we've ended up in a bit of a housing crisis, which is acknowledged by the government. And as a result of that, they're trying to. Well, they've said the planning system is broken. I think that's Boris in the white paper said that. So last year they brought out the white paper as a start of an ambitious sort of overhaul of the planning system, which is it's over 70 years old and hasn't fundamentally changed since 1947. So there is changes afoot, as you mentioned, Vivian. But I think there has been quite a political backlash to those proposals as being too radical, and there's been a bit of a U-turn over recent months. So much so that we saw last week the Housing Minister Robert Jenrick lose his job. Michael Gove is now in position, and I think he's been brought in to sort of review those proposals, and I think it's highly likely that we will see a change in approach to the planning system, whether that's an overhaul or more tinkering around the edges. But I think just but that's going to take time to sort of work out and be clear about how that's going to move forward. And we could be a year away, we could be several years away if you need legislation to be brought in. So I think in the interim, you do look at the plans, but what we have got is a national planning policy which says if those plans that are currently in place are out of date or you haven't got a sufficient supply, then there's a presumption in favour of sustainable development, which effectively means if those policies are out of date, then the principle is, or the presumption is, that planning permission should be granted unless the harm generated by those proposals is more significant, and the benefits of delivering housing and the benefits that come along with it. So I think, as ever, it's on a case by case basis. It's complex, as planning always is, and timing is everything in the circumstances. So I think the advice I'd give is get some expert planning advice to help inform those decisions about when to bring forward your proposals, because without that advice, it's very difficult as a layman to get your head around those things. And as I say, it's different in every authority, the circumstances. So get expert advice is my advice.
Thanks, Dan. But very useful. And you are question 7. And there is talk in the village about no more electricity in the area. How do we overcome this so a builder buys the land? Well, I feel like I've had too much of a breather, and as the chaps know, I do like to talk, so I'm going to take this one on if that's okay with you. And this is an issue that crops up far more frequently than it used to. And at Rosconn, we like to meet this head on. at the very start of the process, we undertake a suite of what are known as developer inquiries to establish who the utility provider for electricity is and who the utility providers are generally for the various services that the development will require. And this will point out where who the provider is, where the service conduits run in any particular location. Having established this in relation to who's providing the electricity, we will then investigate what capacity is in the system. Typically, we'll engage a specialist consultant who may well have a relationship with that utility provider, having worked previously with them, so we can get to know the data that we need to know to ensure that there is enough capacity in the system for our development. It's really important to know this at the start of the process. We always want to know either that there is capacity, or if there isn't, what's our solution to that? How are we going to get capacity into the system and with electricity, to answer your question, into the grid? But it's also really important to monitor what other planning applications are happening in the locality. Is there another development that's going to come ahead of yours? And as I would term it, sort of suck the juice out of the system. So it's very important to be on it early, ensuring that, you know, if you're with a land promoter, they'll be tackling it early. They'll be engaging a specialist consultant, and they'll be getting to the root of it straight away. So hopefully that's answered your question, Anne. Rory, you are asking, we're staying in the area and want to ensure that a high quality scheme is developed. How can we safeguard this and still ensure that our land is sold for maximum value? Yeah, well, Rory, we're noticing this coming up far more often than many years ago when we did a number of smaller schemes. We now handle schemes of up to 1,000 units plus sometimes, and quite often we may be dealing with estates, and there may be legacy issues, and understandably, landowners want to establish that the eventual built development won't deviate too far from what their vision was, what was there in the master plan. At the start of the process, what we like to do as Rosconn is sit down with our master planners and landscape architects, with the landowner's advisor, the landowner, and let's have a design workshop. Let's work through what's the vision, what does the landowner want to see, and what's also going to maximize value. And then that vision's put forward within a master plan, a parameters plan, and that goes in as part of the planning application. It may be in some instances that there is actually a specific design code that is created and is required because the local authority want to ensure that everything that's been promised is just a bit more binding. And therefore, with the protection of both the parameters plan, the master plan, the vision document, and in some cases a design code, the eventual purchaser, when they're buying it, they understand the do's and the don'ts, the cans and the can'ts, in terms of which areas of the land holding are going to be lower density and what type of housing, etc. And if they deviate from that, it's very unlikely that they're going to obtain planning permission. And obviously, if they deviate from the planning permission, they'd be in breach of the planning permission. They wouldn't. They'd struggle in terms of selling the houses. So we like to get onto it very early, sit down with you and your advisory team, work through the desired end result, and go from there, and make sure that within the contract when we're selling, it's there, and in terms of the transfer restrictions on number of units, to ensure that frankly there's no embarrassment down the line. Greg, you're asking, years ago part of the land was used for landfill. There may be contamination on site. How can the cost of remediation be quantified? Great question, Greg. I'm going to take it if you don't mind. As part of the land promotion process, as Nick was outlining, there's some very key technical investigations that we carry out, and one of those, as Nick was referring to, was the geophysical investigation, otherwise known as the GI, or sometimes an SI, site investigation. We're an industry that does love our acronyms. What that report will do, and that investigation will do, is that will identify key areas on your land that have got levels of contamination. Once we as Rosconn are armed with this information, we'll pass that on to a cost consultant, typically a QS, civil engineer, who will be able to quantify, be it removal of contaminated earth, asbestos, variety of different types of contamination that can affect the ground. We'll get that quantified. That then forms a very robust document for an eventual purchaser when they're reading through one of Rosconn's very detailed tender packs. That will be one of the documents contained within it, which allows us to be able to put a figure within a very tight ballpark as to what that as to what the cost of that might be. So it's not a problem if there's been contamination. There'll be some remediation works to do. There'll be a cost attached to that, and we'll work through that with you. So that's not a problem. Now, Sally, you are asking some of the land floods. How can we mitigate against this and ensure that the builder doesn't make the flooding issue worse for the local community? I'd like to take this one, Sally. Flooding, climate change, frankly, the cleanup initiative and agenda that we're all trying to work towards now, it's so important. And we take flooding and flood risk very, very seriously at Rosconn. And one of the key documents that forms part of the planning application, it's the flood risk assessment, the FRA, for those of us that like acronyms. This establishes the status quo of what's happened in the area to date, historically, and what might be likely to happen as we move forward. To be honest, though, Sally, there's nobody that knows the lay of the land, typically than the landowner, the farmer, and therefore that intel, that landowner intel, to feed into that report is absolutely fundamental. Because quite often a number of these consultants can be coming from other parts of the country, and they might not know the lay of the land locally quite as well, or have those anecdotal observations that is really useful when landowners provide. As part of that flood risk assessment that will be carried out, there'll be flood modelling that will be undertaken as well, that will just show that range of different scenarios that could happen over the years, and what that enables us to do is ensure that the drainage strategy caters for those changes, so that a development that we're putting forward isn't making any situation worse. Hopefully, it's helping it. Quite often, we're trying to find solutions to actually reduce flooding that may have happened in an area that may have just been a culvert blocked up, or and we're very used to dealing with these situations to ensure that the flooding issue doesn't prevent you getting development on your land, and hopefully, if we're improving a situation locally, get some local buy-in for the scheme. So hopefully that's answered your question. David, you're asking, from a planning perspective, once planning permission has been secured, is that the end of your involvement in the project? Dan, I'd like you to take this one, please.
Yeah, sure, no problem. Yeah, I guess sometimes that is the case. It's obviously the sooner the site is sold, once securing planning permission, the sooner that we realise the return for the landowner. But I guess there are occasions, and there's certainly occasions in the past that we've to help facilitate the sale of the land, it can sometimes be beneficial to try and discharge some of the pre-commencement conditions. So effectively, we would secure an outline permission that establishes the principle of development. Once that planning permission is, that outline planning permission is issued, there will be a series of conditions attached to that outline planning permission. Some of those will be about the detail of the eventual development, and that will form part of the sort of second stage of the planning application process, known as the reserved matters, where details, what the design of houses, the layout, the areas of public open space and landscaping. But there will always be a series of pre-commencement conditions that need to be discharged before any development takes place. And typically those things cover issues such as archaeology. So before you start building houses, you need to know what's under the ground in terms of hidden heritage assets. So we can look at trying to partly discharge or fully discharge those obligations. We can look at things like Dan's just mentioned about ground conditions and contamination, taking forward the studies, submitting that information to the council to discharge those specific conditions. And what that does is it reduces the burden on the house builder who eventually buys the site, and streamlines that more to help them get on site a lot quicker. And this is one of the issues that is holding up planning permissions at the moment, is discharging pre-commencement conditions, because the councils are focused on dealing with the planning applications themselves, not the subsequent conditions discharge applications that follow, and they're not seen as a priority, but they are the things that help delivery on the ground, and are just as important as the initial outline planning permission and the subsequent reserve matters. So anything we can do to sort of reduce that burden and speed up delivery and make the site more attractive to purchasers, we will look to do. Hopefully that addresses that question.
Yeah, great, Dan. Yeah, no, I think it absolutely does. And would you believe it, we are coming up to our final one of our final questions, and this has come in from Kim. Whilst Rosconn may have developed a good relationship with the local community and made promises about the positive benefits new developments will bring, how can I be sure that these are followed through by the eventual developer? Dan, if you'll round that off for us, please.
Yeah, sure. Yeah, no, good question. And I think it goes back to sort of legacy, and particularly if the landowner still lives in the area or in the village or where the development is going to take place, they want to, they're the first person that residents are going to complain to if something that was promised is not delivered. So I think I think you can probably break this up into two groups. One is a lot of the benefits of any development will be tied up through planning conditions, and particularly the legal agreement called a Section 106 agreement. So that effectively secures a lot of the benefits, particularly the financial benefits. So anything necessary to improve sort of social and physical infrastructure within a settlement. So if you're delivering 100 houses, you're going to have an impact on the local school, doctor's surgery, public transport. So all of those things generate financial contributions. So those need to be paid to the relevant authorities before development has an impact on them. So those are all tied up very tightly within a Section 106 agreement, as is affordable housing delivery. So again, another key benefit of any housing development is delivering affordable housing for local people, that's affordable. And so again, that's something that's delivered as part of that legal agreement. But then again, I think the other sort of side of it is the development itself, what it looks like. Is it sort of high quality? Does it reflect the local distinctiveness of an area? And that's a more subjective issue, and it's difficult to tie down. But I think it's about design codes, the design principles that we try and establish at the outline permission that hopefully influence the final project that the house builders come up with. But again, that's something we want to sort of make sure is of a good quality. Again, it's about the legacy, but I think, you know, we can only go so far with that. It's obviously the principal responsibility will be with the local planning authority, and we know over, you know, recent months and years that government is placing a greater and greater importance on high quality design. Building back better is one of their catchphrases. So I think, you know, we all have a role to play, government all the way down to the local authority, and sort of raising the standard of design and making sure that is fit, you know, for the local circumstances.
Yeah, no, absolutely. Yeah. Nick, did the results of the second poll come in at all?
They did. Yeah, I'll talk through those. And yeah, we've also had a question on those, which I'll just touch upon as well.
Great.
So yeah, the results of those were, so this relates to engaging a promoter, given the, yeah, I think, you know, the complexities, technical reports, etc. required, and 5% promote personally, 45% unsure, and then 50% to use a land promoter. Question came in from Chris, who asked, you asked about whether people are considering using a land promoter or not, but for a first-time seller, it's a difficult question to answer. What is not clear is the risk-reward equation of going yourself or using a land promoter. What are the costs of going yourself versus using a land promoter? How do land promoters charge fees, percentages of sale price, fixed price, something different? Can you talk to this a little, please? I'm happy to sort of start that off, and then Dan, OD, you may want to sort of pick up any bits.
Well, I'll chime in with you, Nick.
Yeah. So yeah, I think the key difference of doing it yourself versus using a promoter is risk. So if you're promoting land personally, then all costs associated with doing so will be borne by you, whereas a promoter would cover all costs associated with getting planning permission and selling that land. So it's a nil cost versus a significant cost of for a sort of modest development of say 20-30 dwellings up. You could be looking at, even if it's straightforward, 70,000-80,000 pounds quite easily, through to several hundreds of thousands or even millions of pounds in for a much larger development. And then in terms of how the promoter sort of takes their cut, it would be a fixed percentage agreed at the outset of the sale price. Yeah, Dan, anything to add on that?
Yeah, no, well, I think you've covered a lot there, Nick, and it isn't a difficult one when you understand the complexities of the system like we do. Dan H has worked in planning for a number of years, and will have, the amount of changes in that time frame, and as he's outlined, could there be some more to come? Nick and I have worked on planning and land sales Nick's been working on them now for 14 years with me, and very risky, very, very risky. There's absolutely no guarantees, and it's not just the expense, it's the time. And if a landowner has a surveying background and planning background, and they've sold land many times before, that may be slightly different. But I think it could be a very daunting process. I would feel very daunted as a landowner that didn't have the experience, just getting my checkbook out and trusting a variety of consultants I might meet for the first time, because it's huge sums of money. It really is huge sums of money, and yeah. So I think really the cost benefit is one where you're not getting your life absorbed all the time by it, and you're having somebody else pick up the tab, i.e. Rosconn, who's traveled that journey so many times in terms of land value maximization. Again, it's not just about getting the planning permission, it's about knitting everything together, as Nick outlined in his presentation: the legals, the technical, the marketing, the sales and marketing, who to go to in terms of house builders, who's keen in the market, who's not. That knowledge base, it's invaluable in reality. And when you then put the typical type of fee that we charge, which is a fee based on the eventual sale price. So there's no money along the way. Promoter covers the cost all along the journey. Yeah, I can understand why 50% had said that they would engage a promoter. So yeah, and I would think actually perhaps many. In truth, I was expecting that to be higher than 50%, if I'm honest. But then that's coming from the knowledge base that I've got of the high levels of risk. So we're happy to take it and maximise your land values. So Nick, I hope that contributed a little bit.
Good. Yeah. Excellent.
Okay. Well. It's come to that part of the show where we have to get ready to say goodbye, which is a great shame because we've enjoyed being with you this afternoon, and it's been our great pleasure to present to you this afternoon. And we hope that you have found the presentation and discussion interesting and informative. We have tried to answer as many questions for you as possible, but for those that didn't get answered, as I said earlier, they'll get answered separately. Rosconn Strategic Land are actively searching for more land promotion opportunities that allow us the chance to add value to both local communities and landowners alike. Please do get in touch if you have some land that you think may have development potential. We offer a totally free appraisal service, and Rosconn will be delighted to provide you with our professional opinions. I'd like to take this opportunity to thank my colleagues, Nick and Dan, and indeed Dee back at the office for helping put this webinar together. And of course, it goes without saying, but the team at Farmers Weekly. Our final webinar is coming up in December, and there'll be further announcements in due course about the subject to be presented and discussed. We just want to hold you in suspense just a little bit longer if you don't mind. But thank you once again for watching this webinar and sparing your valuable time. Rosconn Strategic Land greatly appreciate it, and we look forward to hopefully seeing you next time for what I like to know, or what I like to call the grand finale. If in the meantime, any viewers, your friends or family have land that might be right for development, please do get in touch and we would be delighted to discuss the opportunity at no cost to you, the landowner. Well, that's all from us, folks. So once again, thank you to all of you for sparing the time to listen to us this afternoon. We hope you've enjoyed. Bye for now.